Our last segment today is about what is the world going to look like after the Supreme Court's decision in Epic Systems. And Amy Schulman is our moderator. She was our moderator from the previous panel. Amy's a new member of the advisory board. She is a employee union lawyer for Broach and Stulberg, and we're just super pleased that she's joined our board, and she'll be taking it on from here.
Thank you, Sam. I'm very honored to have joined the board, and I'm honored to be here this afternoon with this esteemed panel. As Sam said, the panel is Employment Arbitration's Future, Non-Mutual Issue Preclusion. And I know on a Thursday afternoon at 4 o'clock, most of you are thinking if only the Supreme Court would weigh in on whether class action waivers are valid or not, we'd have some guidance. So as they have on several occasions now, our panelists are going to address where we go from here. Next to me is Zachary Fasman, who is a partner in the Labor and Employment Law Department at Proskauer Rose. Next to him is Joseph Sellers, who is a partner and head of the Civil Rights and Employment Practice in Washington, D.C. at Cohen, Milstein, Sellers, and Toll. And next to him is Eli Adelman, who is a rising 3L at NYU Law School. So I will not take up any more time and turn it over to the panel to get started.
Thank you, Amy. It is 4 o'clock in the afternoon, and I think the reason that this segment has such an odd title, and you can't quite figure out what it is, it would have made more sense to say employment arbitration after Epic Systems, and that's probably what we're going to talk about. The notion of putting collateral estoppel, non-mutual offensive collateral estoppel, which is also what we're talking about, is enough to make people at 4 o'clock in the afternoon say, "I'll come back in the morning." So you'll hear it. It'll be fascinating. This is in some senses. Let me just set the table for you. To me, this is in some senses a continuation of a speech I gave 2 years ago here, when I spoke about employment arbitration in the wake of Italian Colors and DirecTV, which turned out not to be an important case, but Italian Colors versus American Express, a very important case. And the reason we're talking about issue preclusion is, of course, Lewis versus Epic Systems versus Lewis, which is an extremely significant case that confirms that it's lawful for an employer to demand as a condition of employment that employees agree to class action waivers. That is, that they agree to pre-dispute arbitration on an individual basis for all claims related to their employment. As we all know, in D.R. Horton in 2012, the Labor Board, for one reason or another, decreed that it was unlawful under the NLRA for employers to demand as a condition of employment that employees agree to class action waivers. And the Supreme Court in Epic Systems on May 21st, and through a 5-4 vote, said that the board was wrong. So this is sort of the last chapter in the speech that I began 2 years ago. Now, for those of you who don't remember those brilliant words in that fabulous speech, what I talked about was basically the 3 cases written by Justice Scalia before his passing that set out the modern concept of arbitration as seen by the Supreme Court. In Stolt-Nielsen, AT&T Mobility versus Concepcion, and Italian Colors versus American Express, the court repeatedly emphasized in all 3 of those cases that bilateral individual arbitration was what Congress contemplated under the Federal Arbitration Act. That the benefits of arbitration, the speed, the informality, the lack of expense, the lack of judicial review, all were realized in individual binary bilateral arbitration, and that class actions, particularly class arbitration that adjudicated the rights of hundreds or thousands, or for Walmart, millions of people were not consistent with the premises. For a while, that is right. Were not consistent with the premises of the FAA and what Congress looked at as the preferred form of arbitration under federal law. Now, that does not mean that the parties cannot agree to class action procedures in arbitration. You can, and maybe Joe will tell us a little bit about Sterling Jewelers, which is one of the largest class actions pending in the United States in any tribunal, and that's being tried before an individual arbitrator. But the federal law, as created by the Supreme Court, basically in those cases, says that unless there is a specific agreement by the parties to do something like that, to try cases before an arbitrator, a class action before an arbitrator, arbitration should proceed on an individual basis. It's very significant also to remember that in both Stolt-Nielsen and in American Express, the court was confronted with negative value claims. You know, claims where what you could recover is not worth the cost of litigating the case. And in both of those cases, the Supreme Court said, that's life. In the words of Justice Kagan, who dissented in American Express Italian Colors, she said, to quote Justice Kagan, the Supreme Court's answer, the majority's answer to negative value claims was too darn bad. Life's tough. So that's been run before. So all of this seemed to be, I thought it was pretty clear a couple of years ago. All this seemed to be fine until the NLRB said, no, it's not so fine under the National Labor Relations Act. So D.R. Horton holds, as you all recall, that protected concerted activity extends to the filing of lawsuits on a class or collective basis to improve conditions in the workplace, and that employers violated the National Labor Relations Act by insisting as a condition of employment that employees sign class action waivers. This is after, of course, the Supreme Court had ruled to the contrary under state law in Concepcion and under federal law, as it turned out after that, in American Express. Now, there is precedent for the proposition that filing of lawsuits by employees is protected concerted activity. I mean, Justice Ginsburg in her dissent talks about that, but there's no federal precedent under the National Labor Relations Act that says that you will have the right to file a class or collective action. You may have a right to file a lawsuit, but you don't necessarily have a right to file a class or collective action. And if you read Epic Systems, you'll see that the board took conflicting positions in the case. Peter Robb took one position, the government took another position. It's very interesting to see the board fighting, the government fighting with itself before the Supreme Court. But certainly the board's ruling on Horton seemed very much out of step with the Supreme Court's view of bilateral arbitration as the form of arbitration under the Federal Arbitration Act. Horton split the circuits, ended up before the Supreme Court May 21st, as I said. Justice Gorsuch writes the opinion for the majority, not surprisingly ruling against the board. And he states, and I'll read you just portions of it. He states that while as a matter of policy, the question of whether employees and employers should be allowed to contract and any disputes between them will be resolved through one-on-one arbitration, though that's surely debatable, as a matter of law, the answer is clear. Congress in the Federal Arbitration Act instructed, this is a quote, instructed federal courts to enforce arbitration agreements according to their terms, including terms providing for individualized arbitration. He reasoned that Congress had given emphatic direction in the FAA that when parties contract for arbitration and specify the rules that will govern their arbitrations, their agreements should be, and this is his quote, a quote from him, protected pretty absolutely. He also somewhat humorously noted that, I thought it was funny at least, he also humorously noted that the employee's suggestion, and this is a quote, that one statute, the NLRA, steps in to dictate the procedures for claims under a different statute, the FLSA, and thereby overrides the commands of yet a third statute, the Federal Arbitration Act, was an interpretive triple bank shot that couldn't be accepted. To so hold, Justice Gorsuch wrote, it would be to read the NLRA as forcing parties into class-based proceedings and would introduce new risks and costs for both sides, and the result would be that the virtues, and this is a quote, "the virtues Congress originally saw in arbitration, its speed, simplicity, and inexpensiveness would be shorn away, and arbitration would wind up looking like the litigation it was meant to displace." Have we heard that language before? This is the fourth Supreme Court decision in which that same language has been seen. Justice Ginsburg didn't like any of this. She wrote for a member dissent. She read her dissent from the bench, which is quite unusual. Her dissent says that the majority's opinion is egregiously wrong. She characterized the National Labor Relations Act as an abrasive statute, whatever that means, and argued that suits to enforce workplace rights collectively fit comfortably under Section 7's definition of concerted activities, and she does indeed quote lots of NLRA law. She said that she believed the Supreme Court's Arbitration Act decisions had taken many wrong turns. She claimed that the latest decision was an exorbitant application of the FAA. It goes on like this for a while. It's not surprising that she read it. It's very angry language. And she said the inevitable result of the majority's holding in EPIC systems will be the under-enforcement of federal and state statutes designed to advance the well-being of vulnerable workers, and she invites Congress to pass legislation that will make class action waivers in employment agreements unlawful. In the Republican-controlled Congress and with President Trump, that is not going to happen anytime soon. Don't hold your breath. So the bottom line here is that EPIC systems confirms what we've heard all along, and it basically says that class action waivers in employment agreements are permissible under federal law, and that the benefits of arbitration as contemplated by Congress, speed, lack of expense, flexibility, are realized only in bilateral arbitration. So, what does collateral estoppel have to do with this, right? You're asking yourself. Well, non-mutual issue preclusion is one device that some plaintiffs' lawyers have come up with as a means of dealing with what inevitably will be a broader scope of individualized arbitrations. So maybe we ought to turn it over. Eli's going to talk about legal issues, and then we'll listen to Joe explain why this may not be a panacea, but it might be helpful, and then I will tell you all why Joe's wrong.
Great. Thank you, Zach. So we thought it would be helpful to provide just some very brief overview of the black letter on collateral estoppel, offensive non-mutual collateral estoppel. Me being the closest to 1L civil procedure, I figured I'd take a shot at it. So preclusion law, as we know, is made up of res judicata, or claim preclusion, and collateral estoppel, or issue preclusion. Both have undergone major changes in the last half century or so. Claim preclusion notably has seen a shift from theory to fact-based claims, but today we're talking about issue preclusion, which essentially says that a party only gets one shot to litigate their issue. So it requires that the issue in the second action be identical to the one decided in the first, that the issue was actually and necessarily decided in the first, so not just dicta, and that the first action resulted in a valid final judgment. At common law, issue preclusion required mutuality, which meant that the parties in the second suit were identical to or in privity with the parties in the first suit. And the idea was that it would be unfair to allow, basically, a party who wasn't at risk of being bound in the first action to use that decision in a later action. However, defensive non-mutual collateral estoppel was first embraced by the court in Blonder Tongue in 1971, and that essentially says that a plaintiff who loses an issue can't just substitute in a new defendant. A second defendant can use issue preclusion to say, as a shield essentially, to say, hey, you're stopped from making this argument against me. Mutuality was completely overturned in Park Lane hosiery in 1979, and that's when we see the embraceal of offensive non-mutual collateral estoppel. So that involved an SEC action in the first case for securities fraud, so without a jury, where the defendant was found guilty, and then a group of plaintiffs brought a class action. So there's an important Seventh Amendment question there that we're not looking into, but basically they sought to offensively assert the decision from the previous securities fraud action And the court said that trial courts have broad discretion in allowing offensive non-mutual collateral estoppel. Specifically, the court noted that where a plaintiff could easily have joined in the earlier action, so obviously that couldn't happen here as no plaintiff can join in an SEC suit, or where the application of offensive estoppel would be unfair to a defendant, a trial judge should not allow the use of offensive collateral estoppel. So unfair to the defendant becomes the kind of the key term, and it's not really clear, but the court lays out three considerations. The extent to which the defendants had an incentive to litigate their suit fully and vigorously, the presence of inconsistent judgments, and the possibility that the second action affords the defendant procedural opportunities that were not available in the first action. So this is all very clear in the context of litigation. It becomes a lot iffier in the context of arbitration, and that's what we're talking about today.
Before you go to arbitration, Eli, the Supreme Court has also held in Elliott versus University of Tennessee that the basic ruling that it came up with in the Park Lane case applies to administrative agencies, even state administrative agencies, if they're functioning in an adjudicatory capacity.
Right. And the restatement second of judgments says that arbitration should be given the same preclusive effect by courts as would a typical litigation. But here, the second party, the second adjudicatory forum isn't a court. It's another arbitrator. And that's the issue that that's really the crux of the issue. And
Yeah,
that's
that
what we're
really
looking
is the issue that we're talking about, is one arbitrator being bound by a prior arbitrator's ruling under this doctrine. Now, before you embrace this doctrine, I wanted to say that I did do a fairly lengthy paper for this, and in case you missed...
Which is in the materials.
It's in the materials,
terrific
it's
paper.
outside, and if you missed writing down all the stuff that Eli just said, it's all in there. Go ahead, Joe.
Well, I'm going to try to bring all these two concepts together. Suffice it to say that I don't agree with the majority decision, and I could give you lots of reasons, and I'm going to spare you those because our side lost. But I think what you need to understand as a consequence from the perspective of somebody who's represented workers for more than 30 years is that this, although we will talk about non-mutual offensive collateral estoppel, and it's a cool idea, and a number of us are thinking about how to use it, and we will talk about it today. I want to step back for a moment and talk about the broader consequence of the decision from the perspective that Justice Ginsburg lamented, which is the under-enforcement of the civil rights and employment laws. Small value, economically valued claims are likely to be much less likely to be pursued at all, because the only reason they're economically viable is when they're brought together, and at the moment that's not available. And the claims that may involve large costs or large amounts of time, such as Title VII disparate impact claims, where you may have hundreds of thousands of dollars of expert costs and millions of dollars of lawyer fees, are very unlikely to be brought on behalf of an individual, even if you can then collaterally stop the employer from relitigating the issue if you prevail. So you're going to see, I think, if there are no changes in any respect in this area, you're going to see significant segments of the case law, the cases that have been brought in the past, go away. Maybe not overnight, and obviously it depends a little bit on how many employers use class action waivers in their arbitration agreements, but I would suspect that this is an incentive for many that haven't used it up till now to start using them.
The current statistic is that 25 million workers are covered by these agreements now,
I'll bet you it'll double in a couple of years.
probably.
So the first thing to say before we get to the little segment that's left is that a large swath of what I think of as claims that were only possible through some collective adjudication may very well not be brought. And the laws that are available to those workers to enforce those rights aren't going to be invoked. Putting that to one side, then the question is, what about other kinds of claims that might be possibly viable in some fashion? So the first point is that there may be occasions where if the identity of a number of workers affected by a fairly straightforwardly defined practice, I think of a wage and hour practice involving whether some group of workers are properly classified as exempt or not exempt, or independent contractors or not. And I realize that can be factually complex too, but let's assume we have some very straightforward issue there. And therefore, it can be adjudicated with a limited amount of discovery in a single arbitration. And very importantly, you can identify other workers who have been subject to the same practice. Then the question is, can you bind an employer if the first claimant prevails? Can you bind the employer in a second arbitration against the employer on behalf of a second worker? And if likewise the first decision is adverse to the employee, and the second worker brings a claim, can the employer collaterally stop for the second worker from relitigating a defense or a claim that was rejected in the first one? Well, I think the second issue is very clearly no. There's just no way that a party, an entity that can enforce a ruling against somebody who was not a party to the first ruling. I think that's I think that's so well established. That's not the risk. The question is, if the claimant prevails in the first occasion, can the claimant go to the second, another claimant go to the second arbitrator and say, the employer got that defense rejected as a matter of law. I don't want to have to relitigate that issue. I want summary judgment in my favor, and then I'm going to go to the third and the fourth and fifth. Now, before we talk about the whole legal issue about this, I want to say one other thing. We have, in the past, some of us, including my firm, have had occasions where we have brought hundreds of individual claims to do just that kind of thing, but that has been on occasion when class has been certified, then decertified. So we have hundreds of people who've already opted in, or who were members of the class and whose identities were known, who could be offered assistance. In this world that we're heading into, there may be no certified class. And these arbitration agreements, at least so far, and the companies that administer them, all require that the proceedings be kept confidential, including the fact of the arbitration and the award. So very hard to know how one finds out, other than through scuttlebutt in the workplace, that somebody's brought a claim and that something happened to it, and who else is available, and go see Sellers, he's got a claim representing somebody, and he may be available to represent you. That is a real happenstance process. So before we talk about this, I want to put this in a context of how, in some ways, improbable this may be in a lot of settings. I don't mean to diminish the importance of what we're going to talk about, because where it can be used, it may, I think, be very powerful, but it is in a very small segment of what I think is the broad swath of enforcement proceedings that private parties have brought in the past. So with that in mind, let me just say a word about why I think it's enforceable, and you can disagree with me. So to start with, Eli made a couple of the points I want to emphasize again. The application of collateral estoppel and non-mutual, even offensive collateral estoppel in arbitration is largely untested. It just hasn't been needed. It hasn't been tried very much. There's Zach cites all these things. There's a California Supreme Court that under California law says can't do it. There's a Second Circuit and Ninth Circuit case that say probably arbitrators at least had the discretion. And indeed, when you look at Park Lane Hosiery, the Supreme Court, the court didn't say you have to allow for offensive collateral estoppel. It said district judges have the discretion to do it. That's in fact what I think the prevailing law right now is for arbitrators as well. Doesn't require them to do it, doesn't prohibit them from doing it. But remember that arbitral decisions remain subject to judicial review, which is the only check that you have on their authority. And that is a very limited scope of review. And the question probably would be, did they engage in a manifest disregard of prevailing law if they declined to follow the finding by a prior arbitrator, something that might very well not hold people to very much discipline in abiding by what a prior arbitrator did. They may choose to do it, but they may not be required to do it.
Well, that's right, and that's the current state of the law, which is undeveloped right now, but the current state of the law is application of offensive collateral estoppel in arbitration is totally discretionary, based upon what the arbitrator chooses, and they do not commit manifest disregard of the law by refusing to be bound by a prior award. For everybody who's been involved in arbitration, you know if you go into an arbitrator and you say, I want summary judgment, we won this case 3 years ago, whether it's labor arbitration or something else, the arbitrator says, interesting, let me look at the prior award, go ahead and put your case on, we'll see what happens, right? That's how these things work.
But
So-
Zach, let me ask you a question. You have a prior award where the employee won. If the employee lost, there won't be issue preclusion. And you say to the arbitrator, this is precisely the same issue, and we want to ask the employer, why should the employer be able to relitigate it? Now, some arbitrators are going to take that seriously, some won't, but if they want to get picked again by that plaintiff counsel, they're going to have to take seriously that assertion, it seems to me.
Well, maybe, maybe not. I mean, I think that is a development on a practical level. I mean, it is interesting in looking at these issues. One of the most striking, there's in the paper that's out there, there's no question that the courts have said that they're not bound to do this. There's a First Circuit case, let me read you what the court says. Quote, it is black letter law that arbitration awards are not entitled to the precedential effect accorded to judicial decisions. Indeed, an arbitration award is not considered conclusive or binding in subsequent cases involving the same contract language but different incidents or grievances. Okay? Even further, FINRA, our friends over at FINRA, when they announced that they were going for the first time in the financial industry to require written and reasoned awards several years ago, they specifically, the FINRA rules state, and let me read it to you, arbitrators' opinions, quote, will have no precedential value in other cases, and that, quote, arbitrators will not be required to follow any findings or determinations set forth in prior decisions.
Let me just. Go ahead.
I mean, it's, in other words, when they said, well, we're going to want written opinions from you folks, they also said, but nobody's bound by them.
And in contrast, the AAA employment rules, which have some moment here, actually require a reasoned decision and have no prohibitory language with respect to preclusive effect.
Right.
You could draw an inference from that, maybe not today because they may not have a chance to amend it, but if you wait a year and they have left the language untouched, you certainly could infer from it that AAA intended not to have the language that was put in FINRA.
And this may be semantics, but I think it's important to note that obviously arbitrators are not bound by arbitral precedent, we know that. But is there a distinction between precedent and preclusion? Precedent is meant to set forward the law for society writ large. Preclusion is meant to decide an issue for two parties. And here, that's really what arbitration is all about. It's about efficiency, it's about getting results quick. So I think you can make a point that preclusion introduces a separate aspect, a separate question from precedent. It's not so easily dismissible.
One more thing I would say, and this is a legal matter, and that is the courts are very clear that whether or not an arbitrator affords a prior ruling preclusive, persuasive, no effect is a matter for the arbitrator to decide. It's up to the arbitrator. It's a question of contract construction or legal construction, whatever it is, and the courts can't decide that. Why is that important? Because it precludes Joe when, you would never do this, would you? We've been friends for many, many years, so.
Probably I would.
You might.
I don't know what it is, but I probably would.
Yeah. From going to court and saying, look, I've got 4 awards enforcing this. Now they're requiring me to arbitrate this again. Mr. Fasman's motion to compel arbitration instead of having this court rule on this is ill-taken. as a matter of law, you're bound to preclude him from continuing to arbitrate these cases.
Very well done.
I think that's wrong. Yeah, thank you. I mean, but I think that's wrong. I think I win that argument.
So, look, let me just say a couple things about this. To begin with, one theme that is lurking through this entire discussion, which I think we'll all agree on, is that the decisions by arbitrators are going to be unpredictable. So one of the things that I understand, I don't represent businesses, but one of the things I understand is essential to business operations is predictability in the law. The return of all these decisions to arbitrators who we keep hearing aren't bound by anybody's authority, not even each other, is going to reduce enormously the predictability of the employment laws. And when employer says to Zach, can I do this? I'm sure he's going to give good advice, but he may not have a lot of guidance in a couple of years because the law in this area is all going to be underground. And it's going to be individualized determinations by arbitrators who are going to say, perhaps, I'm going to make that up on my own. I mean, as long as I have a very limited scope of review. I might add that 15 years ago, which I know is a long time ago in the world of the arbitral decisions, in the Mitsubishi decision and some of the earlier decisions which first approved commending to arbitration statutory claims, the antitrust claims, securities claims, Age Discrimination Act, all were predicated on the assumption these are important public rights enacted by Congress, all with the expectation that arbitral forums are on par with judicial forums. It's just a matter of being able to write the rules a little differently. We have since then, in the last 5 years, had a dramatic reduction in the Supreme Court's view about the stature of arbitrators. They're now just private decision makers deciding small cases that can't bind each other, can't group together any claims. And I think if that trend continues, we're going to see, apart from the fact that we may not have much private enforcement in this area, but if whatever is there, it's going to be very hard to advise parties what the law is.
Joe's.
Can I just counter here? Yes.
Go ahead, Sam.
The American Arbitration, I've seen these awards. They are redacted awards under the employment arbitration rules. So you're overstating it, it seems to me, in terms of the secret law. We have unpredictability even in litigated outcomes. We just had a panel here on whether or not prior salary can be a factor other than sex, and I didn't hear any predictability. So you can have unpredictability there as well. I think most employers, if they get a defeat in arbitration in an employment law matter, if it happens twice, they're going to change their policy. They're just not going to be subject to arbitration. Look, it is not a complete win for employees not to be able to resort to class actions. I concede that. But on the other hand, arbitration, these cases go to hearing. The people that are claimants in employment arbitration, I'm not referring to consumer arbitration, they've either lost the job or haven't gotten a promotion, they show up at arbitration. And they're not, to this point, arbitrators are not entertaining dispositive motions. They get to a trier of fact. They don't get to a trier of fact in litigation. Now, it's true, if I can get Joe Sellers to turn my pay dispute into a disparate impact claim on behalf of an entire class of claimants, I am going to be better off. I'm going to have more leverage. But in the real world, I can't get Joe Seller because I'm only making $50,000 a year. And he can't turn it into a class action. So there is another side to this story.
Oh, you can,
Well, I got to respond to
you
this.
can get Joe.
I got to respond.
I can't
to
get
this.
Joe
How
at
much you're making? Come on.
You got to give me a chance to respond to this.
Okay, go ahead.
In many ways. So first of all, let me start with the fact that I have tried to access arbitral awards from the AAA, and nobody can find them. So if they exist, I'd love to know how
They're
to
published by
find
the
them.
commercial
they're on
publishers.
Lexis.
We'll get it for you.
All right, well, please
Joe,
do,
I'm
because
surprised at the
I can't
lack
find
of
the ones that-
ingenuity of the Cohen Milstein
I can't
library.
find them in my own case.
We will get them for you.
So, and they claim that they don't really publish them. So anyway, put that to one side. I think that is we'll have another panel on that one. But put that to one side. I think that you start with people who are current employees, who are fearful of bringing claims against their employer out of fear of retaliation. You've got a whole population of people who are going to be deterred from bringing those claims. So individually. Then the question, can you get Joe Sellers? And there are lots of me, by the way, not just me, and I know you know that. There are a lot of lawyers out there who are prepared to bring these cases and have brought them. And there is a lot of the proof of discrimination turns on patterns of conduct that are not easily discerned in an individual case. So put aside the leverage issue, just the proof of the claim is really hard in a lot of individual cases. Discrimination particularly is subtle and is proved often with statistical evidence and other kinds of evidence, which is just out of reach for individuals in these kind of cases. So I understand that you're pushing back, and that's an important role to play, but I think where I sit in the trenches, those claims aren't going to be brought.
Let me agree with Joe on one thing, and that is I agree
Good,
with you
make a note.
that, you write this down. This won't be the first time. But I agree with Joe that this does water down the public law aspect of this, because if you're having arbitrators rule in case after case after case involving statutory claims, one of the and there's no judicial review, essentially no judicial review on legal construction. That is, the degree to which manifest disregard of the law is a standard. It's not much of a standard.
Right.
But these are not going to be reviewed as would a district court's judgment. For example, think about some of the areas in which we've seen developments in the law. English language rules in the workplace, dress codes in the workplace, all of these other sort of tangential issues that have bubbled up, developed, gone up to the circuit, sometimes gone up to the Supreme Court. You're not going to hear about them because they're all going to be in arbitration. And Sam can say what he wants about AAA decisions, which are available. I agree with that. But they're not going to be reviewed. You're not going to get an appellate court saying this is right, this is wrong. I mean, there's a public law aspect of this that is going to be lost if these cases are resolved through arbitration. Now, do I think that that's wrong? That's an issue. If I'm an employee, do I want to wait 4 years for an age discrimination ruling after it's bopped up and down to the Second Circuit, after I've waited for 2 years to get a hearing date before somebody in the district court in the Southern District? Or do I want to get an award? Do I want to have 5? I mean, this is what I think the bottom of the Supreme Court's rationale. Do I want to have 5 depositions, an arbitrator who understands the law basically, can make rulings on credibility, and can give me the same remedies that I'm entitled to in a federal courtroom? Maybe that's a better solution. I don't know, but I think that's certainly an argument and a way to look at all of these cases.
And indeed, I'm sure that is the rationale of the majority of the Supreme Court. That's their thinking. Just to be clear, I think people on my side of the V in these things are not necessarily opposed to arbitration. What they're opposed to is compelling people to agree to mandatory arbitration as a condition of employment, as opposed to at the time the dispute arises. So, for instance, if I get fired and at that point I'm given a chance to decide, do I want to go to court? Age discrimination case, it could take 4 years. Do I want an arbitration? It takes 6 months. And I think, boy, I want that arbitration because I'm otherwise unemployed. And I think that's a perfectly reasonable choice to make. And in that respect, I would agree with Zach. What I disagree about is compelling people to be signing up for that without having any idea what the nature of the claim is, whether they're going to have a claim, whether it's going to be easy to prove, whether it's going to be hard to prove, what the issue is. That's the part that is a problem. And so when we're not really comparing, in my view, apples and oranges. I know the Supreme Court thinks of it in terms of...
I was just going to say that's a good view, but
Let me-
it
can I-
didn't get
And-
5 votes.
And that's,
I
yeah,
know,
exactly,
I
that's
agree.
that's
That's a
done.
problem.
That's done, so what do we do
Yeah,
now?
that is done.
Well, so come back to the issue of preclusion. I think there are going to be efforts made to try to argue to arbitrators that they should at least take strong heed of a prior arbitral award, assuming that you can find it, and that's the issue. But the prospect of learning who else is out there who may have been subject to the same practice I'm going to go to Zach and say, send me the list of all the other people who are similarly situated in this wage and hour case. And what Zach's response is going to be is unprintable. So I'll
it is
spare
largely unprintable, and you're not going to get that unless somebody tells me that I'm compelled to give
Right,
that to
and
you.
they're probably not going to compel. I
And
mean,
they're
I'll
not gonna
try it.
compel
But
me.
so my point is that even if I
would give it to you, but
well,
my clients
I
would.
know that,
But-
Zach. I appreciate that.
You know, the,
Joe, I mean, I'd give you one.
I know.
but Joe, how is this done now with FLSA cases? You get a couple of people, client comes into your office and says, I got fired and there was no just cause, and you
Yeah.
say, don't tell me how you got fired, tell me how you're being paid. And then you find out, gee whiz, this person's been classified as a salaried
I don't think I do
employee.
that, but
Yeah.
Good, why don't you, let's have a party of all your best friends, and then we have 30 people, that's how it works.
No, Joe,
If
I-
the
actually,
Outons,
it
if the
doesn't.
Outons firm were here
No.
today, we would get them
It
to
really
tell you that.
doesn't.
no, Joe files a class action up
Yeah.
until now, and then basically sends out notice, right? I mean,
Well,
then
then
you
I'm
were
now
talking-
talking about the
these are
FLSA
discrimination
opt-in.
cases.
I'm
Okay.
talking
No,
about the
I know,
FLSA
you're
opt-in.
I know you're talking about.
And so we have a party, and I've got 50 people now. I got to decide how many people I want. Because I have too many people, I'm going to divide up the settlement sum through a very large denominator, and it's not going to be a very sellable settlement. So I only have some. I mean, that's how it works in the FLSA context. Why couldn't it work that way? I don't want some conceptual, give me everyone who's conceivably have a claim here. I want who's working in your department. You have an ADIA notice that tells me about the other people affected by the RIF. I want discovery on who's in those categories. Now, some arbitrators might say, go screw yourself. I know. Then you go and you call up your friends at NYU, which, by the way, I think is a great development that the plaintiff bar has organized, and you say, don't ever use this person again.
Sam, wait a second. Arbitrators, and I know that Judge Roberts doesn't agree with this in the Sterling Jewelers case, but you have an arbitrator who's arbitrating an individual claim. You and I have an arbitration agreement. She's arbitrating our claim, and I don't see what power she has to tell me, and I want to see everybody who is similarly situated. She doesn't have the right, and I know you argued this in the Second Circuit, and I listened to that. It was a very good argument from your side, but I still don't understand how an arbitrator in an individual case between two parties has the power to bind anyone else who's not those two parties.
So-
And you even said that. You even said at the start of this, I wrote this one down, that if an employer wins,
But Zach,
the
we're not
initial
talking about
arg-
binding people here. The question is whether that's going to be disclosure that's going to be ordered by the
Well,
arbitrator.
no, there's
get
a separate issue here as to binding someone else in terms of obtaining this stuff. But let me raise one issue that Joe and I have talked about incessantly almost, which is, let's say that Joe and I are, I'm representing a client, he's got 10 plaintiffs. We have 10 individual arbitrations. He wins them all, okay? And it's on something that my client says, listen, all right, do we have to try all these cases? There are 1,000 people who are similarly situated. Get rid of this nonsense. Let's get this done, right? In a class action, that's easy, right? You got a court who can bind people. But remember, Justice Alito's concurrence in Oxford Health says, I don't get it. Why does an arbitrator have the power to bind anyone? And Joe just said at the start of this discussion, well, of course, if the employer wins the first one, non-parties aren't bound. So how do I get closure? How do I, when one of my clients says, Zach, isn't there some way to wash this stuff? And we agree, mea culpa. We're done. Go negotiate a consent decree with Joe, and I say, I don't know if I can. I don't know who has the power. I mean, these are just individual arbitration cases. Now, one alternative there is for my client to, or for me to say to my client, listen, don't invoke, the next time this comes up, don't invoke the arbitration clause. Don't tell me I have to compel arbitration. Let Joe file a lawsuit. Let him file it as a class action. Before he does that, we'll negotiate a consent decree. It's going to be more expensive, of course, because you've won 10 cases, as you've said several times. But maybe that's a way out of it. But unless you do that, I don't know.
There's no preclusive act. In
There's
fact,
no-
I mean,
yeah.
I mean, look, lot of concepts bundled there. And
Yes.
On the question of power of arbitrators to bind multiple people, it's all about the agreement. The argument is that if the arbitration agreement entrusts arbitrators with the power to decide those things, they ought to be able to bind other people. But in the absence of a class action, which is the case that Zach's referring to, the Sterling Jewelers case, was ruled to be one in which the parties intended to allow class claims. So it's a very different situation than we have here. You don't get, employers don't get the kind of finality that comes from a class resolution where you can give out notice and everybody either opts out or their claims are resolved. Instead, maybe Sam's over there having a party with people to get them to come in and bring other claims. And I may or may not know Sam, and so I'm settling a claim with Zach, and Zach's employer's saying, okay, well, we're gonna pay a premium to you to sellers, because he's got us over a barrel here for his clients.
He's 110 in a row.
But the question is, you and I both know we've got hundreds more people. How can we be sure they're not gonna come forward after we finish this? And I'm gonna say, well, Sam's out there recruiting people, and he could bring a case on behalf of 50 more, and I wouldn't even know about it. So.
You have this problem with FLSA settlements.
We do, anyway.
You do, you have it there.
But,
And if you're offering people money, it's the same point I made this morning with respect to Janus. You offer people money, not trivial money, they're going to get involved. They don't have lawyers, by the way. You're giving them money for nothing on some level. It's
I don't know
like
about
dire
that.
straits, money for nothing.
how
And
about-
they
because
will,
they were
in
subject
other words,
to
you're
discrimination.
enshrining this class action procedure, but the reality is settlement, and people will come and join the settlement. Will the employer get 100% preclusion? Maybe not, but enough.
Well, I don't know.
We'll see.
I don't know.
I'm going to ask Zach in a year and find out whether his clients are satisfied with that as the
I
formula.
mean, enough is, I'm looking at Fred here and all the other management side lawyers in the room and saying, your client's gonna go with enough? Gonna pay Joe, $122 million in behalf of a class
They'll
settlement?
factor that in terms of the value of the settlement.
Well,
Anyway,
Sam,
you're enshrining the class action, which, by the way, I think has a lot of functional attributes to it, but there's a lot that can be done outside of a formal class action.
no,
Yeah.
But there may be a need for some change in AAA rules. I mean, and we should talk about that
well, look,
in terms of
my
sharing
only point-
information.
my
in
only
terms of
point
co-
in bringing this up, Sam, was what do you do with a situation that you posited originally, which is what happens if they're repetitive cases and the employer keeps on losing? Of course, when I start winning these cases, then I don't care, because
If the
it's
employer keeps
inconsistent.
on losing, I cannot believe that an arbitrator that gets through a vetting process that involves neither lawyers and will be chosen if he, in fact, does not say, give me a good reason why I shouldn't follow these prior rulings.
But
What's the difference in this issue? I mean, that's what arbitrators will be doing. Now,
Well-
if the agreement bars it, that agreement should not be administered by places like AAA or JAMS.
Well, I'm not sure that agreements that prohibit preclusion are enforceable.
Right.
Right.
I mean, that's like saying you prohibit the use of the adverse inference rule.
I'm with you on that.
No,
I'm
I don't
with you on
think
that,
that's
Joe.
right. I mean, there's a lot of literature on that, and that says if parties want to contract out of preclusion, they can contract out of preclusion. It's their arbitration procedure. Why can't they do that? I don't see that doesn't follow. Let me also say, as a matter of California law says, and granted, California law has been overturned a million times, it's inconsistent with the Federal Arbitration Act, so I understand that, making this comment. But California law says that unless the parties affirmatively agree to preclusion, the presumption is that the parties understand the difference between judicial and arbitral determinations, and they don't intend to allow preclusion in these circumstances. Right or
Eli,
wrong?
my lawyer over here tells me that's the minority view.
It
so-
is the minority view,
Okay.
no question. But the
This
whole
is in the
point
Fasman memorandum, by the way.
No, but look, my whole point is, whether it's the minority view or the majority view, it's a view that is accepted by the courts and in some states, and why can't I, sitting down, negotiating my arbitration procedure, say,
I'll tell you-
we're gonna get
I'll
rid
tell you
of
why.
preclusion, it's not gonna happen.
I'll tell you why, because the decision whether a decision has preclusive effect is not your choice. It's the choice of the parties in the next arbitration. It's the next forum that gives preclusive effect to a decision in a prior ruling. It's not, you don't dictate the results of that.
Well, the answer to that is, if I'm the employer and everybody signs the same class
Well, you
action waiver, my employees are all bound.
Well, you can say, we won't agree to it. That'll be up to the arbitrator whether that's enforceable.
Well,
And I
think-
would submit that it won't be.
let me,
Can I ask Zach, why would you want your, operationally, why would you want to have the same managers and same employees subject to cross-examination by perhaps many different lawyers on the same issue?
They'll get nothing done.
In different, either before different arbitrators or even before the same arbitrator. I mean, doesn't that subject you to more risk than you otherwise would have?
Sure, of course, there are practical reasons. That's why I brought up what happens when Joe wins 10 cases. How do I get out of this nonsense? My clients are not stupid. You know, they say, all right, get me out of this. How are we going to do this? And my only point was to bring up there's a conundrum in terms of getting out of this if these are all individualized
If I
arbitrations.
could generalize just for a moment, to some extent, the Supreme Court has forgotten that there are sort of inherent efficiency reasons for the class action.
Yeah.
They've gone down this road with Mitsubishi initially. They've given arbitration a public law role since Mitsubishi.
Right.
And it's going to
And they shut
require,
it down.
you know, employers right now are in the catbird seat because, you know, they've got class action waiver. It's the best of all possible worlds. Who wants to change a thing? You know, it's like that old joke, kill all the people you don't like, and you ask this person he's got his last wish, and he says, just give me a Coke, because you've killed all my enemies. I don't need anything else. So the employer's in a catbird seat, but it's not a sustainable equilibrium position. So if there's going to be class action waivers that are enforced, it's going to require some change in the arbitration procedures, in my view, and in terms of, and I'm a big supporter of arbitration, in terms of, in an appropriate case, getting the identity of coworkers. It's going to also require, and I think it's already in the law, that you can get attorney's fees beyond the benefit you've conferred on the particular individual. I've actually written opinions on this, and the Southern District has affirmed it for plaintiffs. And so it's going to require some degree of cost sharing in that sense. It's not your ideal world, I'm not denying that, Joe, but it's going to require that kind of joinder
Wait, let me
procedures.
just say,
It's going to require kind of employers saying to themselves, I want to basically preserve the benefits of arbitration, but I understand it's got to be a little bit different in order to be sustainable.
So,
And it's going to require allowance of non-mutual collateral estoppel in appropriate cases.
well, we'll find out. I mean, certainly one step that could have been taken but was rejected is that you could have, and we do, for instance, in the Sterling Jewelers case, have class actions occasionally litigated in arbitration. You know, arbitrators can be retired judges. This one is a retired magistrate judge. You don't have a jury. We've given up a lot of things already to that point. But I think going all the way to eliminating class actions, you know, we'll find out. In a year or two, we'll have another discussion and see whether
Right.
any of these procedures really work the way that they're contemplated. I come back to a point from the very beginning, notwithstanding your party idea, is that I think it's going to be very hard to locate people who have similar claims, put aside in order to give them the opportunity to pursue claims against the same employer involving the same issue.
Right.
Let me raise one other issue too here, and that is something that has always bothered me about the issue preclusion prior award stuff, which is that arbitrators, there's no requirement that an arbitrator even be a lawyer, number one.
Right.
Number two, that the person have any background in legal issues. And number three, there's no review on the law. I mean, the one thing that the Supreme Court has made clear, the court has said, the parties are free to structure their arbitration provisions as they wish, except in Hall versus Mattel, the Supreme Court said, you cannot expand
The scope of judicial
the
review.
scope of judicial review because it's a judicial issue. Congress said that you cannot expand that. So in Hall versus Mattel, the employer's agreement said, or I guess it was a mutual agreement, said their arbitration awards will be reviewable for mistakes in law.
Right.
And the Supreme Court said, not in this world, they are not reviewable under the FAA for mistakes in law. It's a manifest disregard of the law, which is a very, very narrow concept. So, I mean,
that's a
here's the issue. I mean, when you really think about issue preclusion, and I know there are reasons we've been talking about which makes sense, but when you think about it, an arbitrator who is construing a statute, who's not an expert perhaps in statutory construction, who's not sitting on the bench, who doesn't have law clerks around, says, well, I think this is what the statute means. In the paper out there, I concocted this hypothetical. Guy comes in, says there's been a reduction in force in my workplace. I'm 55. And there are too many folks like me who are 55 years old who are kicked out. And the only statistics the person brings in are the statistics for people who are 55 to 65. That's not legally sufficient under the law. You have to take the whole group from 40 and over. But the arbitrator says, you know, the employer, I argue on behalf of the employer, this is insufficient as a matter of law.
Right.
You're bound by this, blah, blah, blah. The arbitrator says, you know something, that's simple and clear and I understand it, and thank you for your excursus on multiple regressions studies and all the other trash you've thrown in the record. I'm following the 55 to 65. I'm ruling for him, right?
And
You
it's
want to give
unreviewable.
that, and it's unreviewable on a mistake of law. You want to give that award collateral estoppel effect.
But-
you want to have the next person come in and say, hey, I like that award that Joe got with regard to the 55 through 65. I'm in that group.
And
Collateral estoppel.
And even if we all agree that, whether you agree we can get collateral estoppel effect or not, we all agree that the law as it currently exists is that the arbitrators can consider that. They can certainly consider that award, and they may say, well, that sounds pretty persuasive, or even, I'm inclined to give that preclusive effect. And by the way, that decision is also virtually unreviewable. So whether we agree that the arbitrator is bound to do it or not, and I think the existing law at least is they're not bound to do it, to give preclusive effect.
That's right.
And if they have the discretion to do it, I don't see why they would, you know, you might get one or two arbitrators applying it in that context, but are you really going to get enough that it's going to create the settlement
I don't know.
pressures
I
that
don't know.
Professor Estreicher was
You know, there
talking
was a
about?
tendency in these discussions, this is based on 25 years of being in these debates, that we compare what's wonderful and beautiful about litigation to what's absolutely rotten in arbitration.
Right.
And don't assume district judges or state judges are also wonderful. The AAA requires that you be a lawyer and that you be knowledgeable about employment law. We now have an organized plaintiff
No,
bar,
no.
and we should require, we don't have adequate
Not that we know
disclosures
of.
about prior cases. They,
And I think the latter's not right, Sam.
That's not
I don't
correct.
think you have to, you have to be a
could
lawyer.
You don't just have to be a lawyer, but
I
that's
think
it.
that's right.
You don't have to be
could be a patent
knowledgeable
lawyer.
about employment law?
Nope,
I don't think so.
nope.
Well, we'll need to
There's no
change that.
panel for employment.
I didn't say there was a panel, but I think it says you have to be knowledgeable about employment law, but
I
I
don't
will,
think that's right.
They know how to spell it, that's it.
I'll defer.
I don't need
I
that.
think-
I don't think that's right, but look, even if you're knowledgeable
I think we should
about
change that.
Even if you're knowledgeable about employment law, think of the class action that Joe has in Sterling Jewelers.
Right.
I
That
mean-
won't be brought again.
Whoa, I mean, you're talking about
Well, why would Margaret Shaw
statistical
be,
stuff,
she's not
you know?
knowledgeable in employment law either.
Who? With the
Isn't it- well, not Margaret
the
Shaw, what's her name?
arbitrator?
Yeah.
Yeah.
She has presided.
She's a magistrate judge and an adjunct professor at NYU. I know precisely her subject matter,
Well.
but she's
give-
learned in
give-
this litigation,
give-
for
give-
sure.
Give me a
Wait a-
chance to answer.
Go ahead.
She's actually presided, when she was a magistrate, Joe, over 4 or 5 discrimination class actions.
But that's the luck of the draw. She could have had a
Well, I
wholly
know
different
that, but
experience.
that's,
All
you
right,
picked
wait a
her for
Okay,
that
so
reason.
we
Hang on a
need to improve the AAA rule if it doesn't require
Hang
experience.
on a second, there's
All right.
there's some people out here with their
You
hands up who
question- I
want to
got
join
questions.
this debate,
Yeah.
so let's hear what
Yeah,
people
go
have
ahead.
to say. They're back in the back and then you.
Aaron Hlegwa from NYU. I had a question for Mr. Fasman, kind of switching tracks just a little bit. You know, there was a call, I think, that started with Me Too on a lot of companies, including law firms, that they ask in their contracts with associates and employees that they not use, you know, agreements that call for arbitration or have confidentiality. I've seen some public interest groups call for something similar after the recent Supreme Court decision. I'm just curious, for you know, not speaking about your firm in particular, but have you heard of firms, you know, how they're reacting to this? Are they seriously considering it? could you, and what would that conversation be like with clients you have, that probably are using
Oh, sure.
employment
Now, that's-
confidentiality forms?
No, it's an interesting question. I'm not going to talk about Proskauer or any other firm that we know or represent, but certainly there are law students these days who are sitting there and saying, we're not signing an arbitration clause. You don't have the right to.
There's a petition within 5 minutes of
Correct.
that coming up at
Yeah,
NYU.
no, I mean, there's all kinds of pressure, and just as there's pressure on Me Too as a whole, from shareholders, from corporate boards, from activist shareholders, there's a lot of public pressure on this, and this is just one of many. Of course, Congress, in the tax laws, said if you want to be able to deduct a Me Too settlement as a business expense, or Me Too verdict as a business expense, can't be a confidentiality clause.
Right.
So there's all kinds of pressure from the outside. So I don't disagree with that, and maybe that's one solution if there is a problem here. I'm not sure that there's really a problem, but you're certainly right to raise it.
We have time for a few more questions.
Gene Eisner.
I think the five-court majority right now has a very short memory. Up until 1932, it was a condition of employment that employees could not join a union. That was a yellow dog contract. And those yellow dog contracts, under Norris LaGuardia, you can't have that anymore.
Right.
Now, as a condition of employment, you've got to agree to a class action. Let me remind that these five distinguished members of the court, what comes around goes around. So let me propose the following fact pattern to you. A new factory opens up in a town, and they're hiring people, and they must sign saying, as a condition of employment, you will agree that you won't engage in any class action. And they all need to work. Everybody's out of work in the little town, and they all sign. Suddenly, a union organizer comes around, and he says, okay, come and join the union, and we're going to fix that. So they all sign. 100% of the shop signs up. And now the union wants to take a matter up, and on behalf of all of the workers. This is not the union. Each individual is not bringing an action, but the union is bringing it on behalf of the workers. Is the union forbidden from doing so?
That's a good question. I don't know the answer yet, Gene, but that's a good one. Now,
Depends on, you ask Justice Gorsuch.
And
what
by the way, I would
interpretation
say
of concerted
the answer
activities.
is Joe Hill would say, don't mourn, organize.
Right.
yeah, listen. There's a lot of, Gene, there is a lot of the literature on this that's been written so far.
Yeah.
There's a very fertile area. Says, of course, that unions are a way around this, and this is a tool for organizing. I think to some extent it depends on what the class action waiver says, because some of them say I won't even be a member of a class. But the union, remember, in an arbitration, the union is the plaintiff, right?
Yes.
The individual is not the plaintiff.
That's right.
So that's a separate question. I don't think, it's never come up. I've
I
never
mean,
seen it.
some wise person on the Supreme Court right now would say, well, they're bringing it on behalf of the workers, and
Right.
so it's a derivative action
Right.
on behalf of the
It's collective
individuals
proceeding.
who are forbidden.
That's right, they can bring it
who
on
knows
behalf,
what-
on behalf of their members, there's standing on that basis. But I'd like to see the union that is prepared to use that as a primary point of bargaining when they have to worry about job security and a number of other factors. I mean, will they actually get to that as something they're willing to bargain over?
Gene, the other thing is, on Yellow Dog and Norris LaGuardia, of course, that's in Horton. And that's one of the reasons, that case was rejected for lots of different reasons, but
Right.
those are the arguments that are made by the majority in Horton itself.
Yeah.
Right.
Okay, so I want to thank our esteemed panelists and everyone for their good questions,
Well done, as usual.
and suggest that everyone stay for the reception, and thank everyone for attending today.
See you tomorrow morning.